Contracts and third parties. Agreements involving more than two parties. Most contracts are between two parties. However, some involve third parties. As we learned in the slideshow on performance and breach, a novation is the replacement of a party to the contract with the approval of the other party. The third-party beneficiary is the intended recipient of the rights that's identified in the original contract. In an assignment, the contract rights are transferred. A delegation, on the other hand, is a transfer of contract duties. Each of these transfers to third parties creates questions as to which party has the right to sue for contract breach. A third-party beneficiary is a person with a right to sue on a contract, despite not having originally been a party to the contract. This right arises where the third party is the intended beneficiary of the contract, as opposed to an incidental beneficiary. The promisee must have an intention to benefit the third party, but this requirement has an unusual meaning. Although there's a presumption that the promisor intends to promote the interests of the third party in this way, if Andrew contracts with Bethany to have 1,000 killer bees delivered to the home of Andrew's worst enemy, Charlie, then Charlie is still considered to be the intended beneficiary of that contract. So Charlie can sue Bethany, the promisee, if the bees do not arrive. Common examples include life insurance and creditor beneficiaries. The third-party beneficiary has a right to sue the insurance company if the insurance is not paid on the death of the insured. Another example is where the creditor of one party agrees to accept payment from the other party to settle past debts. Creditor beneficiaries are created differently from donees. Similar to the gift versus consideration situations in two-party contracts, the donee beneficiary cannot sue the promisee party but can sue the promisor. The beneficiary of the life insurance policy cannot sue the insured but could sue the insurance company. A creditor, however, can sue both parties for breach. One question that arises is whether the beneficiary has the right to sue when the contract is cancelled or rescinded by the parties. The answer depends on whether the beneficiary was aware of the contract and relied on it. A creditor that assents to receiving payment as a third-party beneficiary can sue if the contract is cancelled, but a beneficiary that was unaware of the contract generally cannot. An assignment involves the transfer of rights held by one party, the original assignor, to another party, the new assignee. Assignment of rights under a contract is the complete transfer of the rights to receive the benefits accruing to one of the contracting parties. No consideration is necessary to form a valid assignment. The assignment of rights can be purely donative. The original assignor does not have to request approval from the other contracting party before assigning rights to the new assignee. However, if the other party is required to make payments to the new assignee, then it must be informed of the assignment. An assignment differs from a third-party beneficiary in that the assignment takes place after the contract is formed. A third-party beneficiary is identified in the contract, and an assignee is identified afterwards. An example of a valid assignment is where the payment due to a contracting party is paid to the third party. The duties of a party cannot be assigned as this would affect the basic contractual agreement. Assignments can be restricted in the contract. However, the language restricting the ability of the parties to assign their rights must be of a certain type. If assignments are declared void in the original contract, any attempts to assign will be futile. But if an assignment is prohibited in the original contract and an assignment is made, the assignee has a right to enforce and sue on the contract if she was unaware of the prohibition against assignments. So what happens in the situation where the same contract rights are assigned several times over? Well, if a party assigns rights to one assignee, then assigns rights to another assignee, the first assignee holds the rights and the second assignee has the ability to sue the original assignor for breach of the warranty of assignment. The general rule is that the first assignee has priority over future assignees when there's a dispute involving multiple assignments. However, the rule is reversed when the assignments are gifts. The assignee at the back of the line is now at the front of the line. The last assignment in time trumps all those coming before it. Where an assignment is about rights, delegation concerns duties. Appointment of a subcontractor is an example of a delegation. Duties can generally be delegated by the parties to a contract. A delegation and an assignment can be accomplished at the same time, although a non-assignment clause also bars delegation. Service contracts involving professionals and specialists cannot be delegated. The duties are specific to the individual. So if the Rolling Stones are hired to perform, they cannot delegate their duties to another band. The contract was for the Rolling Stones, an intent that delegation would be ineffective and unfair to the audience. The contracting party remains liable. Delegation does not release liability for the contracting party. However, both the contracting party and the party that was delegated the duties can be sued if the delegation was for consideration. So the client can sue the contractor for breach and can also sue the paid subcontractor.